William Marbury is an angry man. It is December 1801, and almost a year has passed since President John Adams appointed him a Justice of the Peace for the District of Columbia. To officially complete the appointment, procedure called for the Secretary of State to deliver the written and signed commission to the appointee. But during the hectic last days before the Adams administration left office, Acting Secretary of State John Marshall failed to deliver several of the signed commissions, including Marbury's. New President Thomas Jefferson saw this as an opportunity to make some changes. He instructed Secretary of State James Madison to withhold these commissions. Marbury is the victim of a legal technicality. Where can he turn for help? There is but one hope: the Supreme Court, which is still controlled by Adams Federalists. So Marbury brings suit asking the court to order Madison to explain why he shouldn't be forced to deliver the commission. On February 10, 1803, the Supreme Court begins to hear the case of William Marbury versus James Madison, Secretary of State. John Marshall, who was now Chief Justice, knew there was danger for the Supreme Court if it agreed to hear this case. Angered by the last-minute efforts of the Adams administration to pack the judiciary with Federalists, the Jeffersonians had changed the laws regulating the judicial branch. There was even talk of impeaching Federalist judges. Marshall and his colleagues worried that if they ruled against the president in this case, he might refuse to abide by the ruling, thus creating a confrontation between the executive and judiciary. On February 24, 1803, Chief Justice Marshall delivered the opinion of the court. The justices were sympathetic to Marbury. Yes, he had a legitimate grievance. Yes, he was entitled to a remedy. But, the decision went on, the Supreme Court could not legally provide that remedy. The justices found that the provision of the Judiciary Act of 1789 authorizing the court order that Marbury sought was unconstitutional. That could have ended the matter. But Marshall went on to explain why the court had the authority to determine the constitutionality of an act of Congress. He argued that the Constitution is the supreme law of the land, and it is emphatically the province and duty of the judicial department to say what the law is. In a brilliant piece of legal maneuvering, John Marshall had granted the Jefferson administration the result it wanted in this case. But in the process, the court claimed a power it had never so explicitly claimed before: the power of judicial review. In allowing the executive branch to win a battle, John Marshall had made it possible for the judicial branch to win the war. Jefferson and his supporters were quick to realize what John Marshall had done. They did not challenge the decision itself, but they denounced the manner in which the Supreme Court had reached it. What right did the judicial branch have to tell the executive branch what was and was not constitutional? Interpreting the Constitution, Jefferson argued, is a right that should be left to each of the three branches in judging its own actions. Jefferson and other critics also said that the issues of constitutionality should ultimately be left to the people, as voiced through the representatives. Arguments pro and con have echoed ever since, as the principle of judicial review became a generally accepted part of America's constitutional democracy. Our history was changed forever by the words expressed on that winter day in 1803, when John Marshall read the Supreme Court's decision in the case of Marbury versus Madison.